This is Stefan Schmidt for InsiderIowa.com. This week we are all very interested in a gun control case that the United States Supreme Court is hearing. It is one of a series of cases in recent times. One was the case of Washington, D.C., which had a gun regulation that basically banned handgun ownership. A homeowner who was concerned about simply protecting his home in a city that is well known for crime filed the suit. And what's so amazing about the United States is that an average citizen can get the towering heights of power and of government to actually listen to their case. And he won. And Washington, D.C.'s gun control law was declared unconstitutional because it interpreted the Second Amendment, the so-called Right to Bear Arms Amendment, in a way that overreached government power to regulate gun ownership. This case involves a very restrictive law that the city of Chicago has passed. Chicago, as you may know, in 2010 has a terrible gang problem and a terrible violence problem. And especially in some of the lower income and minority neighborhoods, there are gun battles every night. People die. A lot of school children actually have been killed, either deliberately or as bystanders. And a group of citizens was so desperate that they convinced the city to pass a very restrictive handgun ordinance. And in those same neighborhoods that I'm talking about, there are homeowners. And one of them, an elderly African-American gentleman in his 70s, I believe, said, "We, the homeowners, are the only ones in this neighborhood who can't defend ourselves and don't have a right to a gun. The gangs don't pay any attention to the new restrictive gun law, and I think it is unconstitutional for the government, in this case the city of Chicago, to deny me my Second Amendment right to own a gun." So it's an interesting case because you've got gun owners on the one hand, people who want to avoid violence on the other hand, and the Supreme Court will be sitting down to try and figure out, in this particular case, how to reinterpret the Second Amendment for modern circumstances. There are many people who feel that the right to own a gun is a natural right, that it is not a right that you are given by government, that it is not a right that the Supreme Court can give you, but that essentially it's a natural right. I had a gentleman call my radio show when we talked about this issue who argued that very forcefully. Others say that, as with anything else, it may have been true during the colonial period that people could own things and do things without government regulation. For example, you could own horses, you could have a buggy, you could ride into town to get your grain and your supplies and so on without having to pass a driver's test, without having to have a seatbelt on your buggy, and without having to have a license plate on it. That's certainly true. It would probably be unfortunate if in 2010 we allowed people to drive the equivalent of buggies today, which would be all those cars and semis and other vehicles out there, without some kind of government regulation, without some way of knowing who's driving what, and without some instruction on how to operate those vehicles. And so with guns, I think the same thing might pertain, that it may be true that once, you could just buy a gun and own a gun and carry a gun. It was a natural right. Probably in an urban industrial society where people are packed into cities and so on, where we have weapons that are extraordinarily dangerous or effective in killing people, machine guns and automatic rifles and so on. We need some sort of management of that right to own a gun. But the Supreme Court case, in the case of Chicago, I think will be about too much regulation, and then we will move on to some more cases where this issue will continuously be fine-tuned. Stefan Schmidt for InsiderIowa.com.